All right, good morning. This is Kristen O'Neill with the New York State Committee on Open Government. We're here today to talk about the New York State Open Meetings Law and give a nice overview of the statute and talk a little bit about the recent changes in the past year and a half, 2 years. Things have sort of gone back and forth a bit, as I'm sure many of you are aware, with the requirements of the Open Meetings Law. So we will talk about those changes and what public bodies are required to do generally, and specifically we'll focus a little bit on the video conferencing, the remote access aspect of the Open Meetings Law. For those of you that may not be as aware of what the Committee on Open Government is, we are a New York State agency. We're administratively housed within the Department of State, but we are an independent state agency. We provide advice and guidance and legal opinions regarding the Freedom of Information Law, the Open Meetings Law, and the Personal Privacy Protection Law. Personal Privacy Protection Law only governs the privacy of how state agencies are required to maintain personally identifiable records and access to those records, but that only relates to records maintained by state agencies. So if you work for a local municipality, you don't really need to worry about complying with the Personal Privacy Protection Law. So today, obviously, we're going to focus on the Open Meetings Law. Also, so you're aware, I do these programs on a monthly basis. I've been alternating between the Freedom of Information Law and the Open Meetings Law for, I think, going back to perhaps December of 2020, I think is when I started. I've been doing the programs, and I do try to record the programs and put them up on the on our website. There's a section on our website called training recordings and training material. So that information is up on our website. So if you are interested, this content is not going to change particularly from month to month, but there are, as updates to the law occur, of course we will address any updates that occur. So don't feel like this is something that you need to do on a monthly basis, particularly if you're a public employee. But if you take the class, or if you take, sit through the presentation and think it's helpful, let others know about it and keep sharing the good news of open government. Up on the screen, you'll see my contact information. So I'm the Assistant Director. I've been with the Committee on Open Government for almost 6 years now. That's my email address. If you have questions about Freedom of Information Law or Open Meetings Law, you're welcome to contact me via email. That's our office telephone number. It's the best way to reach us, any of us that work for the Committee on Open Government. We are a small office. Up until about 3 weeks ago, we were an office of 3. Within the past couple of weeks, we were actually been lucky enough to, just today, a senior attorney started with us. And a couple of weeks ago, we had an Excelsior Fellow start with us. An Excelsior Fellow is a recent college graduate, or excuse me, law school graduate, a recent law school graduate. So we're very lucky to have some increase in staff in the past couple of weeks, and I'm excited about being able to do some work that maybe that's been going by the wayside, but still being able to provide that day-to-day services that people appreciate. So, but the best way to get in touch with any of us is through the phone number up on the screen. Even if we're telecommuting, the phone gets forwarded to a cell phone, somebody will answer. That's our website. It has changed in the past year. It used to be based off of, the URL used to be based off the Department of State. Now we have our own URL, so it's www.opengovernment.ny.gov. The Open Meetings Law is codified in Article 7 of the New York State Public Officers Law, but the easiest way probably for you all to find it is just to go to the Committee on Open Government's website. We have a copy of the Freedom of Information Law on our website, the Open Meetings Law. We have a copy of the Personal Privacy Protection Law, advisory opinions, and case law summaries, in addition to some other helpful information. We try to provide any updates regarding the statutes on our website or anything interesting that's coming up that we think relating to open government. We get that up on our website. So the Open Meetings Law governs the conduct of meetings of public bodies. The term public body is defined as any entity for which a quorum is required in order to conduct public business in which consists of 2 or more members performing a governmental function for the state or for an agency or department thereof. It also includes committees or subcommittees of the larger public body. So the factors here is, are there 2 or more people acting collectively to perform a public function? Is there a quorum necessary to conduct public business? Honestly, if you're not sure if a quorum is required, the answer is probably yes, that a quorum is required because there's a provision of general construction law that defines quorum that essentially says that any time a public body has the authority, I believe it in the definition of quorum, it's 3 or more people, but whenever 3 or more people have been given the authority to take action, then the definition of quorum applies. Do they have the authority to act collectively? So here we're talking about the New York State Legislature, county legislatures, city councils, town boards, village boards, school boards, fire board, boards of commissioners, any sort of entity that performs any governing body of a governmental entity are generally considered public bodies subject to the Open Meetings Law. And if you have a larger public body that then is broken down into committees, the committees that are made up entirely of members of the larger public body are also public bodies subject to the Open Meetings Law. So, for example, if you have a 9-member school board and 3 people have been designated to serve on the finance committee for the school board, then the finance committee of the school board becomes its own public body that is required to comply with the Open Meetings Law. When the Open Meetings Law was passed in 1976, the declared legislative intent stated that it is essential that public business be performed in an open and public manner, and that citizens be fully aware of and be able to observe the performance of public officials. The law also states that the citizens have the right to attend, and listen to the deliberations and decisions that go into the making of public policy. So that's language pulled straight from the Open Meetings Law. However, as many of you might be aware, the past year and a half has brought a little bit of upheaval with relation to the Open Meetings Law. Back in March of 2020, Governor Cuomo declared a state of emergency, a declared disaster emergency, which allowed him to issue executive orders suspending certain laws or aspects of laws. So that executive order was in effect from March 2020 until June of 2021. In June of 2021, the executive order was rescinded, the declared disaster emergency was canceled, and the executive order was rescinded. So at the end of June of 2021, all public bodies were required to go back to the open meeting, to complying with the Open Meetings Law as it existed prior to the COVID pandemic. Then, on September 2nd of 2021, Governor Hochul signed into law Chapter 417 of the laws of 2021, which in part authorizes most public bodies. When I say most public bodies, it's my understanding it's everything but the New York State Legislature. So unless you're a member of the New York State Legislature or have questions about how the New York State Legislature functions, Chapter 417 is going to apply to you. Authorizes most public bodies to meet and take action authorized by law without permitting in public in-person access to meetings, and to authorize that such meetings to be held remotely by conference call or similar service, provided that the public has the ability to view or listen to such proceeding and that such meetings are recorded and later transcribed. For those of you that may have been familiar with the former executive order that had been in place, you'll notice that the language is, I believe, identical. I think it's substantially identical to the executive order that was in place from March 2020 to June 2021. So if you became comfortable with the requirements of the executive order, we're back in that same place right now. The Chapter 417, this amendment is currently only in effect through January 15th, 2022. Unless it's renewed by the legislature and the governor, it will be repealed on January 15th, 2022. I think the hope is at this point is to get us, to create a bit of a safety net in terms of the COVID, the health emergency, to get us through a couple of more months to see where we are in terms of getting our numbers back under control and having people feel safe going back to in-person meetings. That's not to say that the legislature may not decide to extend Chapter 417 or perhaps amend the open meetings law in some other way, but at least this Chapter 417 gives everybody some breathing room, and it was sort of a quick fix that allows people to, public bodies to, again, have remote meetings. So we have on our website, we have a short guidance document that basically explains Chapter 417 and refers you to some advisory opinions that talk about the executive order. And so if we analyze the executive order, the analysis will be the same for Chapter 417. So take a look on our website, you'll see a section specifically dedicated to Chapter 417. Definition of meeting. Meeting is defined as the official convening of a public body for the purpose of conducting public business. So it's very broad. It includes the use of video conference for attendance and participation by members of the public body. In addition, Chapter 417 authorizes public bodies to meet and take action authorized by law without permitting in-person access, and authorizes that meetings be held remotely by conference call or similar service. So the original, so to speak, open meetings law would require that all members of the public body either be together in person, physically in the same room, or that they had to gather together through the approved use of video conferencing. And when I say the approved use of video conferencing, I really just mean that certain requirements relating to video conferencing that needed to be met, but I'm not going to delve into that too deeply right now because it's not in effect and we don't really need to worry about that right now. Currently, if a public body wants to have an entirely remote meeting, it is free to do so. It is not required to do so, though. I just had a I just want to let people know that I'm not going to be answering questions during the presentation. If you have questions, if you could enter them into the chat function, and I will go over them at the end. So you can have entirely remote meetings. You are not required to have entirely remote meetings. A public body is free to continue to have in-person meetings if it chooses to do so. If it chooses to do so, it has to comply with all the aspects of the open meetings law, regarding adequate space, ADA compliance, etc. But if instead a public body chooses to prohibit in-person attendance or to substantially limit in-person attendance, then it is required to provide the public with some sort of remote access. It could be by live streaming the meeting. It could be by providing a telephone call-in number or a video conference call-in number. It could be broadcast on public access television, but it has to be contemporaneous remote access. Recording the meeting and posting it later is not sufficient to comply with law. A public body must make contemporaneous remote access available to the public. Important to keep in mind that there is no authority for a public body to take action outside of a meeting held in compliance with the Open Meetings Law. While Chapter 417 is in effect, a public body may meet via the use of teleconference and video conference. However, meetings via email are still prohibited. A public body may not vote or take action via email. Earlier, I mentioned that the word quorum is defined in New York State General Construction Law, and it's defined as whenever 3 or more public officers are given any power or authority, or 3 or more persons are charged with any public duty to be performed or exercised by them jointly, or as a board or similar body, a majority of the whole number of persons or officers gathered together in presence of each other or through the use of video conferencing, or right now gathered together through the use of remote access as contemplated by Chapter 417, shall constitute quorum. So what this means is, in order for a public body to do anything, it has to have a majority of the total membership present at a meeting for there even to start thinking about taking action. And whenever it votes on an issue, an action must be approved by a majority of the total membership, regardless of the number of people that are currently present at the meeting. If you have a public body that at full strength is made up of 9 members, the quorum will always be 5. It will always be 5 regardless of the number of people that are actually present at the meeting. If you don't have 5 members present at the meeting, you might as well cancel the meeting because there's nothing you can do. You can't move forward on anything. You need to have a quorum present. And in order to approve any action item, you would still need the approval of the majority of the total membership. So you would need at least 5 people to vote in favor, regardless of the fact that there may only be 5 people present. So again, while Chapter 417 is in effect, members of a public body that participate remotely by conference call or similar service count towards a quorum. They can fully participate in the meeting and they can vote. So if you have a public body where the majority of members are present in a physical location, but some of them are participating either by conference call or by WebEx, Zoom, whatever the case may be, they count as if they were physically present in the room. They are allowed to engage in the deliberations. They can vote. They count towards a quorum. They can vote. It's as if they were physically present in the room. You do not need the majority of the total membership of the board in any one physical location for a quorum to exist. As many of you might be aware, during the height of the pandemic, it might not be unusual for each individual member of a public body to be in their own physical location. Maybe the meeting was being held by Zoom or by WebEx, and each member was in their own home or office. You don't need to have a quorum in one physical location. It's perfectly acceptable while Chapter 417 is in effect as long as you're participating by that teleconference, web conference, whatever the case may be, they count towards a quorum. Even under normal circumstances, even when Chapter 417 is not in effect, or if it does get repealed in January of 2022, you still don't need to have a quorum in any one physical location. And I use the example of the Committee on Open Government itself, because it's an 11-member committee, and we always, during non-COVID circumstances, we would establish 3 different meeting sites that were open to the public. one in Albany, one in Buffalo, and one in New York City. And you could have the body split up pretty evenly among those 3 locations, which would lead to no quorum being physically present in one location. And that's fine, as long as they were together through the use of video conferencing. And now, with Chapter 417 in effect, as long as they're together through the use of conference call or similar service, they count towards a quorum. Prior to the passage of 417, in order for a member to attend and participate via video conferencing, the open meetings law required that the public be provided with an opportunity to attend, listen, and observe at any site at which a member participates. Since Chapter 417 authorizes public bodies to meet and take action without permitting in-person access to meetings, public bodies are not currently required to comply with Section 103C of the law. So in other words, if you have members of your public body that are attending virtually from their homes or offices, the meeting notice does not need to include a statement that the members are attending via video conference, nor do you need to include a statement, include the address from which they're video conferencing from. So that's in effect currently through January 2022. Prior to Chapter 417, notice of the meeting was required to include those locations of the meeting, including the locations of the members who plan to attend via video conferencing, and the notice was supposed to include a statement that the public has the right to attend the meeting at any of the locations. Again, this is something that's been lifted by Chapter 417. The meeting notice does not need to include the locations from which members are attending and does not need to include the statement that the public has the right to attend the meeting at any location. If a public body chooses to allow in-person attendance at its meetings, whether it's entirely in-person or whether it's a hybrid situation where you're offering both in-person and virtual attendance, the public body must comply with the following provisions of the Open Meetings Law. Public bodies shall make or cause to be made all reasonable efforts to ensure that meetings are held in facilities that permit barrier-free physical access to the physically handicapped. This is, from shorthand, I refer to it as ADA compliance. If you are opening your meetings to the public, the locations that are open to the public must be ADA compliant. In addition, public bodies shall make or cause to be made all reasonable efforts to ensure that meetings are held in an appropriate facility which can adequately accommodate members of the public who wish to attend such meetings. So again, if you are having in-person meetings and if you are opening your meetings to the public, you must make sure that you have at least one location that can physically accommodate the size of the crowd that wishes to attend. And this is really true of this would be true of, if you're having a fully in-person meeting or a hybrid meeting. If you are offering both options, if you're offering in-person and remote access, you still need to make sure that you have a physical location that can reasonably accommodate the size of the crowd that you anticipate will want to attend in person. So now we have a question is, are you having a meeting that's governed by the Open Meetings Law? So the first issue you'd address is there a quorum present? For the Committee on Open Government, if we have 6 of our 11 members present for the purpose of discussing public business, then yes, you're having a meeting subject to the Open Meetings Law, regardless of the intent or lack of intent to take action, or regardless of how you characterize the meeting. You can call it whatever you want, but if you have a quorum of your public body present for the purpose of discussing public business, then you are having a meeting subject to the Open Meetings Law. There is no legal distinction under the Open Meetings Law between terms such as workshop, work session, agenda session, budget sessions, regular meetings versus informal gatherings, pre-board meetings. None of those terms have any legal meaning in terms of the open meetings law. Ultimately, you just come down to asking the question, do you have a quorum of a public body gathered for the purpose of discussing public business? There are other types of visits or other types of gatherings that may not rise to the level of a meeting subject to the open meetings law. Some examples might be a site visit. If a public body is going to a physical location, a privately owned, particularly physical location, for the sole purpose of gathering information, but they also have to be reminded to refrain from engaging in discussions and deliberations. If they are going solely for an information gathering trip, in my opinion, in our opinion, courts would likely find that that is not a meeting subject to the open meetings law. Perhaps you have a contractor or an architect or a building facilities director, somebody taking the board members on a tour of a piece of property or a building that's owned by the public, or yes, by the public, whatever the case may be. If it's simply for information gathering purposes and not for discussing or deliberating on public business, the likelihood is the court will find that it's not a meeting subject to the open meetings law. And this has some practical implications as well, because if a public body is going to visit a privately owned piece of property, it doesn't really lead to, practically, you can't really require that a privately owned piece of property be open to the public. If a member of a public body wishes to attend a committee meeting that they do not serve on, they must be free to do so. If you're concerned that by allowing non-committee members to attend a committee meeting, that a quorum of the larger public body will then be triggered, then you want to make sure that those non-committee members sit in the audience and do not discuss, do not engage in discussions with the committee. They need to act as if they were members of the public. They need to essentially just sit there and zip their lips and not engage in the conversation. Otherwise, there could be an argument made, perhaps, that you have a meeting of the larger public body and not just a meeting of the committee. And of course, you know, many municipalities have social gatherings where a public body could be, is going to be invited to, whether it's winter holidays, whether it's a summer barbecue, whatever the case may be. Many municipalities have some sort of maybe social gathering. And there's nothing wrong with members of the public body attending that social gathering as long as they refrain from engaging in substantial deliberation, excuse me, not even just substantial deliberations, any discussion of public business. They want to refrain from having those conversations collectively as a body. So meeting requires physical presence or video conference, and while Chapter 417 is in effect, it can also be through video teleconferencing. You cannot conduct a meeting via email, but this does not mean that members of the public body cannot share information via email. So what I mean by this is if you have a member of a public body that reads an interesting article or comes across valuable information that they think would be helpful to share with other members of the public body, or perhaps members of the public body want to share a draft document for input before discussion at the open meeting. Perfectly acceptable to share that information via email. There's nothing wrong with public bodies, members of the public body sharing information with each other via email. What those members of the public body want to do is refrain from engaging in substantial deliberations relating to the issue that will then go up to vote. You don't want it to appear to the public that all the decisions have essentially been made via email and that the vote is just a rubber stamp at the meeting. People want to hear, the public wants to hear members of the public body engaging in the deliberations, having discussions about pros and cons of a particular issue, and having those conversations in public. So if you do start engaging in those conversations via email, it's important to then, again, repeat those conversations in public, so in an open meeting, so that the public knows that you've taken into consideration certain issues. Notice of a meeting. Every notice of a meeting is required to include the date, time, and location of the meeting. If you are having remote meetings, strictly remote meetings, and with no in-person access, you must include instructions for virtual attendance. For example, I mean, if it's live streamed through YouTube or Facebook Live or broadcast on public access, you want to, indicate a web address or a channel or whatever the case may be. If it's going to be a webcast, video conferencing, which would allow for people to log on or to call in, you want to make sure that you're providing the web address or the telephone number or both for that virtual attendance. So notice, of course, must be given prior to every meeting to the media, must be posted in a designated physical location, and must be posted on the agency's website. And when I say notice must be given to the media, there's no obligation under the Open Meetings Law to purchase a legal notice. It's just that the media must be notified that the meetings are taking place. In terms of timing, for any regularly scheduled meeting, you must provide at least 72 hours notice prior to a meeting. So anything that's been scheduled at least 1 week in advance, notice must be given at least 72 hours prior to the meeting. For meetings that are held on short notice, notice must be given to the extent practicable at a reasonable time prior to the meeting. The law is silent on when a public body can have meetings on short notice. It doesn't say that it has to be for emergency purposes. However, the courts have weighed in on this. The courts have suggested that the propriety of scheduling a meeting less than a week in advance and providing less than 72 hours notice is dependent upon the actual need to do so. For example, if some harm would occur to the municipality, to the public body, by waiting, by not having the meeting on short notice, then the courts are going to find it is acceptable. If the courts look and see that, this was not an emergency, this could have waited into the next regularly scheduled meeting, the court might find that the meeting was held in violation of the Open Meetings Law. Minutes of a meeting of a public body must include a record or summary of all motions, proposals, resolutions, and any matter formally voted upon. A public body is only required to prepare minutes of executive session if action is taken in executive session. So voting is permitted in executive session if the topic is appropriate for executive session and if it is not a vote to appropriate public money. Anytime a vote occurs that involves the appropriation of public funds, that vote must occur in public. If a public body simply deliberates in executive session but does not vote in executive session, there's no obligation to prepare minutes of that executive session. Minutes must be prepared and be made available to the public upon request within 2 weeks of an open session and within 1 week for an executive session. But again, that's only if action is taken in executive session. It does not matter whether the records are unapproved, whether the minutes are unapproved or in draft form. So if you have a town clerk that prepares the meeting minutes 1 day after the meeting or 2 days after the meeting, and they are in unapproved or draft form, if someone makes a Freedom of Information Law request for those draft minutes, they must be provided. There's no obligation under the law to post minutes on an agency website or a public body's website. I highly recommend it as a matter of convenience for all parties to post minutes online. I think it's a considerate thing to do for the public, And in addition, it probably cuts down on the number of requests for minutes that a municipality or clerk for the public body is going to receive. So it just helps all parties involved. If you are in the practice of posting your minutes online, and if you want to wait until after they've been approved, that's fine, because there's no obligation to post them online in the first place. So if you do want to wait until they've been approved before posting them, that's not a problem. Just keep in mind that if someone makes a FOIL request for the meeting minutes before they've been approved, you have to make them available. Recording. Any meeting of a public body that is open to the public shall be open to being photographed, broadcast, webcast, or otherwise recorded and or transmitted by audio or video means. And here I notice a place where I neglected to update a slide. My second bullet point there says an agency is not obligated to record, but I neglected to mention that if you are having, under Chapter 417, if you are having if you are prohibiting in-person meetings and instead you are only offering a remote option, Chapter 417 does require that you record your meeting and later transcribe it. So that I need to remember to update this particular slide. An agency may establish reasonable rules to limit disruption and interference, and model rules for recording meetings can be available on our website. Executive session. An executive session is part of an open meeting. It is not prior to or separate from. A motion must be made during an open meeting to enter into executive session. And the motion must be specific enough to reflect to the other board members and to the public that you are going into executive session for a proper purpose, and then the motion must be voted on in public. Then, if all appropriate steps are taken and it's an appropriate motion to enter into executive session, the public body can then meet behind closed doors to discuss certain topics. And here up on the slide right now, which are available on our website, so if you go to our website, these slides are available already on our website. Here is the list of reasons that the law allows a public body to enter into executive session. Some of them are used pretty infrequently, and some of them are used on a fairly regular basis. For example, discussions regarding proposed, pending, or current litigation, where a public body is discussing litigation strategy relating to a lawsuit that it's involved in. That is permitted to occur in executive session. Keep in mind that this it says proposed, pending, or current litigation. It does not say potential litigation. Everything a public body does is subject to potential litigation. So that's not what this is for. This is not a mechanism for discussing sensitive topics that could possibly lead to litigation. It is for discussing matters where there is an actual clear intent to file a lawsuit, such as a notice of claim, for example, or that the lawsuit has already been filed either by the municipality or by someone against the municipality. Collective bargaining negotiations pursuant to the Taylor Law can occur in executive session. Discussions relating to the medical, financial, credit, or employment history of a particular person or corporation, or matters leading to the appointment, employment, promotion, demotion, discipline, suspension, dismissal, or removal of a particular person. That can be discussed in executive session, and I'm going to talk about that a little more in just one second. And the proposed acquisition, sale, or lease of real property held by a public body, proposed acquisition, sale, or lease of real property by a public body, or the sale, proposed acquisition of securities by a public body, but only when publicity would substantially affect the value thereof. So an example here is that there's a piece of property that's up for sale, and the municipality is considering purchasing the property. and the public body wants to go into executive session to discuss what they're willing to offer for the property. And that would be permissible under the open meetings law, because if other interested parties knew how much the municipality was willing to offer, it could put the municipality in a weakened bargaining position. The same might be true if they're trying to sell a property. If a municipality is, or any sort of government agency is attempting to sell a piece of property, perhaps the public body wants to go into executive session to discuss assessment or an appraisal of a property to see how much the property is worth and how much they want to put it on the market for. And again, the point of this is to make sure that the government agency is not put into a weakened bargaining position by having these conversations in public. I just want to remind everyone, I try to remind everyone every time I do one of these programs. Of course, I still continue to see this word in minutes, and I still continue, if I listen to a recording of a meeting, I continue to hear it, so I clearly have not gotten through to everybody. But when you are moving to enter into executive session, if by the time I retire, I can get all public bodies to stop using the word personnel, I will feel accomplished as a public servant. The word personnel is never used in the open meetings law. So there should never be a motion to enter into executive session to discuss personnel issues. It is not specific enough. The courts have clearly stated in numerous decisions that the motion to enter into executive session must have enough specificity so that the public knows you are going into executive session for a proper purpose. And just saying personnel does not reflect that. The actual language is the medical, financial, credit, or employment history of a particular person or corporation, or matters leading to the appointment, employment, promotion, demotion, discipline, suspension, dismissal, or removal of a particular person or corporation. This could involve you have an open position and you've received 20 resumes, you can only choose one person, and you want to discuss the resumes that you've received in executive session. You would make a motion to state that we are entering into executive session to review applications and resumes to fill position ABC. Perhaps you're going to say that we're entering into executive session to discuss a pending disciplinary matter. That's fine. You don't need to identify particular employees. You don't even need to identify a title if identifying the title would tend to identify an employee. You just need to be specific enough to reflect that you're going in for a proper purpose. And you shouldn't really just parrot the language of the statute. Like just reading all of this language back as part of the motion, again, doesn't really reflect to the public that you know you're entering in for a proper purpose. Pulling out the appropriate language to describe exactly what you're going to discuss is the best way to approach it. I get questions probably almost every day from individuals asking about their right to public comment and public participation. And I'm sure they're always disappointed to hear from me that there's nothing in the open meetings law that requires public bodies to offer a time set aside for public participation or public comment. Of course, as many of you know, many public bodies do offer this time. They set aside a time at every meeting for public comment, public participation, but it's voluntary on their part. It is not a requirement of statute. This is distinguished from public hearings that are governed by other statutes, not governed by the open meetings law. The hearings are governed by other statutes that may require, and probably are going to require, that the public, that the municipality, that the government entity receive public comment on a particular issue. But that is not a requirement of the open meetings law. If a public body is going to allow public comment or public participation, it is allowed to establish reasonable rules regarding that public comment period. For example, common rules relate to time limits, perhaps to subject matter. Perhaps you say due to time limitations, we are only going to accept public comment on items listed on the agenda. Perhaps you're going to establish a rule that prohibits public comment relating to specific public employees. We don't, public comment shouldn't be a time to complain about specific employees. If you are going to have such a rule, you also have to prohibit positive discussions relating to public employees. So for example, if you're not going to let someone complain about your highway superintendent, you can't let somebody get up and sing the highway superintendent's praises. That's about establishing reasonable rules and implementing those rules fairly and consistently. For example, with time limits, you want to make sure that if you are letting people whose viewpoints you agree with speak for 3 minutes, you also need to let the people who have viewpoints you don't agree with speak for 3 minutes. Fairly and consistently. That's what the courts are going to look to when they look to see whether a public body has acted appropriately with regard to public comment and public participation. Under the Open Meetings Law, proposed resolutions, laws, rules, regulations, policies, or any amendments to any of those items, and any records or portions that are public, portions of the records that are public under the Freedom of Information Law shall be made available upon request prior to or at the meeting. If the agency has a regularly and routinely updated website, they should also be making those records available online prior to the meeting. Let's use a fairly common example of records being reviewed at a planning board meeting or proposed resolutions, part of the agenda packet. And here I'll point out that there's nothing, the word agenda is not used in the Open Meetings Law either. There's nothing in the Open Meetings Law that requires a public body to prepare an agenda or to even follow an agenda if it's prepared. But if a record is scheduled on the schedule to be discussed at a meeting, and it would be available under the Freedom of Information Law, then it must be made available prior to or at the meeting. And if the agency has a regularly and routinely updated website, it should be made available online. The law states that an agency may, but is not required to, spend additional money to implement this section. So earlier we talked about executive session, and there are 2 mechanisms for meeting behind closed doors. The first is the executive session, which is a part of an open meeting. And the second mechanism for meeting behind closed doors is an exemption. If an exemption applies, the Open Meetings Law does not apply. It's as if the Open Meetings Law does not exist. And the 3 exemptions contained in the statute are judicial or quasi-judicial proceedings, except proceedings of the Public Service Commission and zoning boards of appeals. Examples of this might be a board of assessment review, ethics boards sometimes serve as judicial or quasi-judicial proceedings. There are certain circumstances where a public body serves in a judicial or quasi-judicial role. And the judicial or quasi-judicial aspect of the gathering is exempt from the requirements of the Open Meetings Law. The second exemption is deliberations of political committees, conferences, and caucuses. So for example, if you have a town board that is made up of 3 Democrats and 2 Republicans, the 3 Democrats, even though they represent a quorum of the public body, are permitted to meet behind closed doors in a completely exempt manner, exempt from the Open Meetings Law. They don't need to notice the meeting. They don't need to open the meeting to the public. They can't vote at these political committee meetings. They can't take action at these political committee meetings, but they can discuss whatever they want at these meetings. There's one exception established by case law where the topic of conversation must be limited to political business, and that's if you have a public body that is made up entirely of a single political party. So if you have a town board that instead of being split 3-2 is made up where all 5 members are adherents of the same political party, the courts have held that the public body, or in this case the political committee, must limit its political committee conversations to political business and then have discussed public business during an open meeting. I know that's sort of, it's a little of a fine line there. The third exemption is to discuss any matter made confidential by federal or state law. With school boards, this may relate to discussions regarding students and their education records that is confidential by federal statute. A meeting with an agency attorney where for the purpose of requesting and receiving legal advice would be covered by the attorney-client privilege and therefore would be exempt from the open meetings law because it is confidential pursuant to New York state law. It is confidential pursuant to civil practice law and rules. Anything covered by the attorney-client privilege, and that's where the attorney is playing an active role. You can't just have your attorney present in the room and say covered by the attorney-client privilege. Excuse me, don't have a clear voice this morning. The attorney must be playing an active role in the conversation. They must be, listening to the legal questions being presented by the board, and they must be providing the type of legal advice that comes from their specific expertise, their education as an attorney. If that's the case, that gathering of the board with the attorney is completely exempt from the open meetings law. It can be held completely separate from the open meetings law. It can be held during an open meeting, but instead of stating that you're going into executive session, the public body wants to state that they're having an exempt portion of the meeting pursuant to the attorney-client privilege. Many public bodies make a little bit of a mistake here by stating that they're going into executive session when in fact it's not executive session, it's an exemption. So municipal attorneys and public bodies want to make sure they're using the correct language here. Non-compliance and enforcement. Enforcement of the open meetings law is through the initiation of a civil practice law and rules Article 78 proceeding. If a petitioner substantially prevails, the court has the authority to award costs and attorney's fees to the petitioner. It can invalidate the action, any actions taken at a meeting held in violation of the open meetings law or taken as a result of substantial deliberations that occurred at a meeting held in violation of the open meetings law. If the court finds that the public body engaged in more technical violations as opposed to substantial violations, the likelihood is they are not going to invalidate the action, but the more substantial the violation, the more likely it is that the action is going to get invalidated. Another penalty built into the law is that if a petitioner substantially prevails against a public body, the public body may be required to take training from us at the Committee on Open Government. So finally, I'm just going to remind everyone that anyone is welcome to contact the staff of the Committee on Open Government by phone or by email with questions. Whether you're a government employee, whether you're a member of the public or a media representative, anyone is welcome to contact our office with questions. There's our telephone number. In addition to my direct email address that I provided at the beginning of the presentation, email address that's up on the screen right now is our office account, where all the staff has access to that account. So if somebody's on vacation or out of the office, anyone can respond. I'm going to close out. All right, just a second. Stop sharing. Okay, now I'm going to go into our chat function and start kind of skimming through some of the questions. If I believe I addressed it, maybe someone asked a question and then I addressed it after the fact, I'll probably skip over it. So if you feel that I didn't answer your question, that might be why I didn't answer your question, but you're always welcome to email me after the fact. I'm going to remind everybody at this point that this training is being recorded and that it will be available hopefully by early to mid next week on the Committee on Open Government's website. The training material is available on the Committee on Open Government's website. I do have to ask, because this always happens, I get inundated with requests for copies of the slides and the recordings, please just look at our website. It's going to be there, I promise. So I'm not going to be able to respond to individual requests for copies of the presentation or the recording. Please just look on our website. The first question here is there a requirement when the transcription has to be available? This person follows up by saying we had been told upon request when the executive order was in effect. Yeah, the law is silent. Both the executive order was silent and the law is silent with regard to time limit. There's no, yes, I think upon request is a perfectly acceptable response as long as the original recording still exists. You want to make sure that you have something to work off of, and that it doesn't get destroyed before a transcript is prepared. You want to look to see what the record retention period would be for that transcript, because if the retention period has expired before it ever being prepared, you may not, maybe you don't even end up needing to prepare it. My personal opinion is it's a slight bit of overkill if you have a recording, the transcription request requirement, but I was not in the room when the executive order was being drafted, nor when the law was passed. I just don't know that it's a necessity. If you are a member of a public body or work for a municipality, I would surely encourage you to use the easiest mechanism available to you to prepare that transcript. Zoom and WebEx have transcription services available. There are other programs that can take a recording and convert it to a transcript. I personally used a program called AI Otter. It's not an advertisement. I'm not getting paid for this. I'm just letting you know that I personally have used that program. It's AI, like artificial intelligence, and then Otter, like the animal. So I would certainly, please, if you work for a municipality, I don't want people to be spending hours and hours on end preparing transcripts when there's so many other things to be doing, nor do I want the municipalities to have to go through the expense of hiring a court stenographer. That's not a requirement of the law. So if you can take advantage of a simpler mechanism that's available to you, I encourage you to do that. The next question is, if some members of the public body choose to attend in person and some via video conference, do the latter need to be in a public area where the public could also be in live attendance with them? So no, the answer is no. We talked about that during. So if you have members of your public body video conferencing, they do not need to open their location to the public. If there is a hybrid meeting with a posted Zoom link, does the meeting still need to be recorded and transcribed? In terms of hybrid meetings, Chapter 417 relates to situations where you are prohibiting in-person, where a public body is prohibiting in-person attendance. If the public body is not prohibiting in-person attendance and is simply providing remote access as an above and beyond service, I don't think the recording and transcript would be required, because Chapter 417 only applies to situations where a public body is prohibiting in-person attendance. Do keep in mind, though, is that if you record a meeting at all, there are record retention periods that apply to that. So just double check your record retention schedules put out by the New York State Archives and make sure that if a recording is prepared, that you're keeping it for that long. Sorry, I'm skimming through. Someone asks practical questions about who's responsible for setting up the live feed. That's not governed by the open meetings law. That's a practical question that each municipality has to answer. This person goes on to ask, can they post a link on the town website for access? Yes, 100%. It should be included in the meeting notice, which should be included on your website. So if you're posting your meeting notice on your website, which many municipalities should be doing, or government agencies should be doing because they have the ability to do it, that meeting notice should include the live feed address. Someone asked I saw a meeting notice that said the agency is meeting remotely but will not be live streaming but recording it and posting it later. Is that allowed? The answer is no. It has to be contemporaneous. The public body must offer contemporaneous remote access. The question then talks about the word transcribe. Is this different from taking minutes? Yes, 100% different. Transcription is sort of what it sounds like. It's a word-for-word transcription. That's what they mean by transcription. Minutes is what required under Section 106 of the Open Meetings Law, which is fairly bare bones. Minutes only require a record or summary of all motions, proposals, resolutions, and any other matter formally voted on and the vote thereon. There's nothing in the Open Meetings Law that requires a description of public comments or a description of deliberations. You can do that if you want to, but it's not required by law. Transcription is word for word. If an agency offers a public meeting space and remote options for meeting, does the meeting need to, I think we already answered that question. Is it necessary to publicly disclose the physical location of remote members of the public body? We talked about that during the presentation. Minutes are not the same as transcripts and recordings. Are transcripts only required if there's no in-person access? That is my interpretation. Yes, if a public body is allowing in-person access and there'd be no obligation to provide remote access, and there'd be no obligation to record the meeting or prepare a transcript. Someone asked a question about a specific board, whether it's open to subject to the Open Meetings Law. I'm going to ask that person to contact me directly because it's not something I know the answer to off the top of my head. I just would need to look into it. The next question is who can call executive session and who decides who it is comprised of. That's not addressed by the Open Meetings Law. In my opinion, any board member that has a right to make a motion has the right to make a motion to enter into executive session. The follow-up is who is it comprised of? I mean, generally the public body or the members of the public body are the only people that have a right to attend executive session. The public body can invite other individuals into the executive session. My opinion is that that would need to be approved by a majority of the board. Like, for example, if there is a disagreement among board members as to whether a guest should be allowed into executive session, then there should probably be a vote on whether that person should be allowed in. The town has open meetings. Are they still required to offer remote access? Well, that's something we've talked about, that it's permissible. Offering remote access, prohibiting in-person attendance, and offering instead remote access is permissible but not required. Can a planning board have its board and presenter in person but require the public view contemporaneous online? In my opinion, yes. If you want to have your public body physically present all in one room, and perhaps maybe, as they say, the presenter, maybe the applicant, whatever the case may be, if you want to have those individuals physically present in a room, you can prohibit public in-person access as long as you're providing contemporaneous remote access. Someone says public access to locations for hybrid meetings is not required per Chapter 417, but once expired, this is required. So pre-COVID and during the period of July and August, when the Open Meetings Law as originally drafted was in effect, if every location from which a member of a public body was participating had to be included in the notice and had to be open to the public. So for example, again, using the example of the Committee on Open Government, we would have 3 locations. Some of our members would be in New York City, some would be in Albany, and some would be in Buffalo. All 3 of those locations needed to be included in the notice, and all 3 needed to be open to the public. This is also true if you have a 5-member town board with 4 members at the town hall and 1 member in Florida or Italy or down the street at their home. It doesn't matter. If you're going to allow that person to video conference, if that person is taking advantage of the video conferencing option, their location has to be included in the notice and has to be open to the public. But that's only, again, that was pre-COVID, and that was during the months after the expiration of the executive order and prior to the passage of Chapter 417. I have no idea what's going to happen on January 16th, 2022. If there are amendments to the open meetings law, it would be great if that occurred perhaps prior to the expiration of the repeal of the current law, but we have to all sort of sit tight and see where we are. Another question is, our publication of record has announced is going out of business in October. Can we use only our website to announce our meetings? No, it doesn't. Again, the meeting notice doesn't need to be, you don't need to purchase a legal notice, but you do need to notify the media. So you need to figure out who the most appropriate local media contact is, or more than one contact is, and that's who you should be notifying that the meetings are taking place. It doesn't have to be your publication of record. You do not need to purchase a legal notice, but it's a statutory requirement that you notify the media of your meetings. So that's the last question that I have in my chat function. I'll remind everybody that I'm always available for questions after the fact. You can send me emails, you can give me a call. We're available, and hopefully maybe the next several months, couple of years, we'll be out in the public doing sort of more in-person programming, which I look forward to. I hope everyone has a great day. Thank you. Bye-bye.